second session. Uh, I can see that most of you have continued from the first session, but still, for those who are joining us for the first time, the objective today for the two sessions was that we discuss different kinds of structures to access India. Even though we have focused by and large on AIFs, we have discussed fund terms, but we are also happy to discuss any tax related issues, or if you are facing any questions from investors, maybe you are a custodian or a fund manager. What are the aspects coming up, and what's the use of these structures? I think we'll be happy to take it up. Again, to introduce, I lead the fund formation practice at the firm. Shrikant is a senior member, and between us, we hope to cover now on open-end structures. Again, to give you a little background, with this, what we mean is funds which allow investors to come in and redeem their participation. By definition, closed-end fund means that investors are logged in. Typically, they are set up like a blind pool with a defined term of the fund. You are taking a huge, engagement with the fund manager. So you are very selective on which fund manager you're backing, because you're locked in that relationship over a 8 year, 10 year horizon. Not that you can't be invested in open-ended structure also, but as a investor, you have the right to redeem your position unless there are any lock-ins or there are other economics attached to it. But as an investor, you can always pull the plug on your participation, which is why it's easier for investors to access managers on the open-ended platform, and it is easier for even first-time fund managers to come out with strategies, because investors know that they have some amount of liquidity to their participation. Now, open-ended structures so far in India operated out of the mutual fund platform. We never had anything to do with alternatives. Portfolio management scheme at one point in time till 2010 was allowed to be on a pooled basis, but after that, even that became depooled. So there was a actual period of lull when venture capital fund regulations were going on, and AF regulations were yet to be introduced. When we really had no other alternatives with open-end structures apart from the usual mutual fund regime, which obviously was very confined to very few AMCs who meet the capitalization requirements and so on and so forth. So 2014 AIF regimes sort of came into play. Category 3 AIF were allowed to operate any strategy they wish. The very first Category 3 AIF was designed by us by a team which is now acquired by Edelweiss, Force Fund Capital. It's now public. So there the objective was actually at that point in time to invest in commodity derivatives. At that point in time, SEBI was only regulating securities market. It was still with FMC the other end. So we actually saw tough issues and so on and so forth. But even there, SEBI was very clear that we do not restrict investments in any opportunity. As an AIF, please feel free to invest. If the portfolio is regulated by another regulator, then that is something where we can't help you much with. But from our perspective, pretty much everything open. The next wave of opening up happened when there was some amount of clarity from income tax department for category 3 AIFs. 2 years back they clarified that any SSC holding an asset for more than 12 months, even in case of listed shares, can take a view that these are capital assets, and accordingly the treatment would be that of capital gains, versus something which is non-cash equities like FNO or other bespoke strategies. Then in that case, there is still a risk that is out there. During the course of the session, we'll also discuss what are the usual healthy practices as a fund manager you can adopt to sort of mitigate or ring fence the tax risk of an FNO strategy running alongside a core strategy which perhaps could be more cash equities. Uh, During the session, we'll also discuss obviously the tried and tested FPI regime. There are a lot of issues that the regime has thrown up. SEBI kept coming up with a series of FAQs, sometimes with consultation, sometimes without any consultation with the market. And accordingly, you had issues that arose in April last year when they, somehow stopped NRIs from managing FPIs and asked them to shut shop. We as a firm took a strong position, represented the industry, and we actually got the regulator to come back and in September, through the HR Khan committee recommendations, that let's take a step back. Let's allow all the regimes or even NRIs to manage the FPI come in through the AIF, and all the clarifications sort of came out. What has again happened is that in the current recommendations, they have said that instead of allowing fund managers 2 years, to sort of ensure that they have non-NRIs as investors and so on and so forth, they are now proposing to clamp it down again to 180 days. They feel that there could be evergreening of structures that a manager launches a platform, runs it for 2 years, winds down, again starts running for 2 years, and so on and so forth. Again, we feel that this is not in line with the messaging to the investors. You would want to tell them that you have thought through all the circulars you're issuing. So, accordingly, when you issue a circular which allows managers bandwidth of 2 years to again bring it down to 180 days, again disturbs a lot. So again, the Khan committee recommendation is something that we will take up during our discussions. The third bucket could be around the gift city structures, how structures could be set up in gift city, invest in India through the FPI route. At the same time, you get all the tax advantages of being in gift. There is no GST, business income is also tax exempt. A view could be taken that if you're investing through the FPI route, then even though you may be set up in gift, the income would be treated as capital gains, and accordingly, there would be at least one layer of tax to be paid. So, again, while we have slides that we put together, but at the same time, we'll be happy to take any questions that you have. To the best of our ability, we'll try to respond to it. I think that could be a fair summary for what you have lined up for the next hour. So maybe Shrikant, if you could.
Sure. So, like Richie said, we can take it slide by slide, but of course, happy to answer any questions that come. The basis of open-ended structures, like Richie said, is that there is a possibility of a continual churn, and there often is a continual churn in investors. They can often redeem their positions, and that typically is linked to a certain amount of liquidity that they have even in their asset class. So, which is why, from a like we started on the close-ended PEVC structures, fund strategies plays almost, or if not more, an equally important role for open-ended structures. So typically, you have structures where either the manager is following a long only strategy or a long short strategy or an FNO strategy, or a whole host of intermediate hybrid strategies that can be followed. Again, like Richie touched upon, the securities are also increasing. There is possibility for equity investment. There's possibility for liquid debt investment. Now there's also possibility for commodities investments. There are derivatives also. On the FPI side, again, you are also having the possibility of issuing ODI. So there are ODI subscribers also possibly. So a lot of these factors also do play out in terms of how the fund itself is designed, how the fund documents are designed, how different valuations may be calculated, etc. Similarly, like Richie said, equally important is the exit window, especially for open-end structures where there is an expectation of exits. Uh, how the GP goes about constructing that, whether they want to place some gates, whether they want to place some exit loads, whether they want to place some lock-in requirements, and how that plays out vis-a-vis the market. Again, one issue we did touch upon earlier in our earlier session, but which is quite important here, is with the renegotiation of tax treaties and with almost every jurisdiction essentially ending up, if it is the investor jurisdiction, also having India as a charging jurisdiction, then the FIFO issue and first in first out. How do you then ascribe values in an open end setup, especially when maybe somebody has invested and you use that money to invest in a portfolio, but somebody else has put in a redemption pressure. So how do you allocate the tax liability between these different investors? Again, in a situation where SEBI may not be very conversant or very forthcoming until maybe the Khan committee report giving some hope on SPC or PCC sort of structures, which are otherwise the norm across the board. So that is how fund strategies can affect the fund structures and fund documentation. The different structures that can be employed, some of the typical ones we have seen is, of course, the FPI structure. So the FPI, of course, can be anybody. An individual can be an FPI, a trust can be an FPI. There are broad-based funds which can be FPIs. There are university-related endowments, government-backed sovereign wealth funds which can be FPIs. So FPI itself is not a structure, but FPI is one of the ways of investing in India, and so in that sense, an FPI structure is one of the ways of accessing the market. Uh, the other possibility is like in the case of PVC, but possibly not with the same amount of tax efficiency, is a unified structure where you have a feeder fund set up maybe in an offshore jurisdiction for similar reasons that the investor may not want to take up some sort of tax exposure in India. The investor may be more comfortable investing in another jurisdiction, contractual enforcement, etc. So for those reasons, when you have a feeder structure, you are often faced with questions because typically in a feeder structure, the master fund in India would end up being a category 3 AIF. And in a category 3 AIF scenario, the tax pass through is not provided for under the Indian Income Tax Act. So you are relying on some tax risk by relying purely on the principles of trust taxation, though they may provide you with an effective pass through because it is not statutorily encoded. There is some greater risk element involved. There is also that trustee element which we spoke about, since most of these organizers trust, maybe the trustees may want greater protections. So to that extent, and sorry, one more point is that a resident versus a non-resident taxation on this may be treated very differently. So if I had a pass through, I would be assured that I will only have been treated the way I would be treated if I had invested directly. Whereas here, since the category 3 AIF itself is not a pass through, it's itself an assessee entity. The consequence may be that the resident taxation could also slightly affect the non-residents' ultimate taxation. The third structure, therefore, which is probably more prevalent in a category 3 or an open-end format as compared to a PVC format, is the co-investment structure, largely for the same reasons that I mentioned, because of this uncertainty around taxation. Possibly, maybe you may not want to combine the domestic and the overseas pools. So, probably co-investment is still one of the more popular structures in this sort of asset class when compared to the others. Finally, I think Richie's also touched upon it, is on the gift IFSC structures. We did earlier cover gift IFSC AIFs and how they have now been permitted, so that equally applies to category 3 AIFs and how they may be permitted. Even otherwise, a lot of the current gift city funds and products are largely focused on the market. So to that extent, there is more resonance currently with open-ended structures. Um, so that's on the structures, which if you want to add something on the
No, I think
structures. Or...
we have also seen structures where domestic brokers have entered into like a JV of sorts with a foreign distributor, where the foreign distributor literally sets up the feeder vehicle in the routine jurisdictions like Mauritius or Singapore and so on and so forth. And the Indian brokerage or the Indian manager sets up a domestic AF, a Cat 3 AIF, especially in traditional long strategies where you're only doing cash equities and there is certainty that this would be taxable at 10%. Then in those cases, master feeder structure works wonderfully well. And depending on who introduced the investor, you can have some split of the fee, some split of the performance, and so on and so forth. So, increasingly, but only recently, feeders on top of category 3 AFs is also something they're looking at.
So this is a depiction of a normal FPI structure. I think it's self-explanatory, but effectively you have an FPI vehicle somewhere in an offshore jurisdiction. Now the Khan committee has recommended that even a gift city unit should be allowed to get an FPI registration. The only condition that it really needs to overcome is that it's not resident in India, quote unquote. But if that concession can be given, then probably we'll also start seeing FPIs out of gift city itself. So this would be a usual structure. In a lot of cases, FPIs do have investment managers or investment advisors. In a lot of cases, the FPI itself may not satisfy certain criteria. So FPIs themselves are divided into three buckets based on the risk assessment and government policy. So the first bucket is government-backed institutions, sovereign wealth funds, where there is a lot of comfort that these are stable long-term investors and that they bring in some respectable capital. So they have a lot of concessions also attached to them, in that their KYC is much more reduced and they are able to do more than category 3 FPIs, as I'll get to. The second category is a category 2 FPI, which is largely appropriately regulated broad based funds, or funds which have appropriately regulated managers. So, to that extent, again, there is some sort of governmental comfort that they do represent some sort of respectable capital, that they are being regulated elsewhere. Again, that helps a lot in simplifying their KYC at the time of registration, and in sort of continuing uh, KYC requirements, PMLA checks, etc. Finally, is a category 3. Somebody who's not a category 1 or a category 2 eligible will have to go in for a category 3 license. Here it's in terms of even restrictions, you are more restricted in your programs. You're not able to issue ODIs, for example, and your level of KYC and PMLA checks are also higher.
I'll just add that ODI subscription T-notes happen where you identify the exact portfolio you want to track, and on top of it, the FPI can write a contractual note. Usually, ISDA contracts are followed. What happens is global banks with enough balance sheet outside India carry out these sort of businesses, where what they do is they engage with the counterparty, say which underlying asset you want to take an exposure. They hedge their position by actually holding the underlying stock or derivative position. The only caveat is that 2 years back, SEBI came out with a position that if the underlying position is a derivative, then an ODI cannot be written unless that derivative in India is only to hedge a equity position. You can always use a derivative to hedge another derivative position, or so on and so forth. Or maybe you issued a derivative up top, but you're hedging your exposure through equity, but that would be very expensive. So SEBI has only allowed ODIs or P notes to be written when the underlying is equities and no longer derivatives unless it's for hedge. The second piece is that now they have also woken up to the fact that there is sometimes a portfolio level hedge. What happens is that a larger bank like a GS or MS and so on and so forth, they in India may have actually held up complete bucket or bouquet of securities, and on top of it they issue these ODIs, these contract notes. So if I have to give dividends or if the price goes up on the ODI contract, I am also hedged because I'm holding the underlying position. So there need not be a one-on-one mapping of the ODI that I've issued and the underlying asset that I'm holding to hedge. So what happens is I maintain a portfolio, and that portfolio gives me that assurance that I'm hedged. So SEBI has now woken up to the fact, it seems, and they're now saying that we want a mapping, not just on a one-on-one basis, but even if you maintain a portfolio and there is a ODI you've issued on top of that, then that also needs to be reported. Now, those who follow the ODI, market, they would know that at one point in time, ODIs used to be 50 to 60% of the entire exposure that sub accounts at that era used to have. Uh, Progressively, laws have been amended, circulars have been introduced, which has made issuance of ODIs difficult. Subscribing to ODIs also equally difficult. And SEBI has always encouraged direct participation. They don't want investors to come in, take exposure to India without getting themselves regulated, because it adds a lot of volatility. So it is a stated policy. RBI, Minister of Finance, through various committee reports, have the first line has always been we cannot ban ODIs at this point in time, and accordingly, the following is what the committee observes. So they've always wanted to ban it, and effectively they have tried to kill it by A, discouraging ODIs, and B, encouraging direct participation through FPIs. And that is precisely what motivated that as a regulator they stepped out, introduced the entire framework for custodians to operate as a DDP. So there's a lot less for SEBI to do, and the regulator plays a lower role, makes it easier for foreign participants to come in and register themselves. So ODIs still do hold a lot of sway, and a lot of liquidity is tracked by the ODIs. Yeah.
Lot of these ODI instruments that are issued and the underlying that is there, many of the FPIs don't even record them in the books. Is that correct? I mean, they show it as an off-balance sheet thing, saying it's contingent. And it's a one-to-one thing. We just write as a pass-through, and our income is the commission income that we make on the buy side, and then the issuance of the ODI.
No, so see the
Especially in light
yeah.
of the poem risk, the asset test, which
No, the issues are slightly more than poem. So what has happened is that SEBI has come out with a very technical definition of what is an ODI. any overseas derivative instrument tracking its value from an Indian underlying and hedged. So if I've issued a contract outside India but never hedged, it's not an ODI because then there is no volatility. What happens outside India does not affect India. So only if you have hedged position, then SEBI expects the reporting. Earlier it was on a monthly basis. Now they're saying even mid-month, if there's any change, if you've issued any ODIs, you have to report that. So it is all tracked, and if people are not doing good reporting, then in that case we have also seen instances of SEBI banning some of the FPIs from operating in India. Right. So the reporting framework is pretty stringent, and SEBI does focus a lot. So, irrespective of the tax issues and so on and so forth, advisable to always report.
Surprisingly, it's kept out of GAR also.
It is kept out of GAR on the ODI side.
The ODI.
The ODI, there's a reason to keep it outside GAR because the taxes have already been paid by the FPI. The beneficial owner of the underlying portfolio is still the FPI. So the FPI has paid tax. So then you should not be paying taxes on something which has already suffered one layer of tax. That's the only logic.
So I think that helps to get into the next discussion point. Around FPIs, taxation wise, they have a special tax regime under the Income Tax Act. They have certain concessional rates of taxation and sorry, certain other tax benefits. For example, the indirect transfer issue does not affect investors of a category 1 or category 2 FPI. So there are certain benefits that the FPI regime provides apart from regulatory, also on the tax front. The ODI benefit was also just touched upon vis-a-vis GAR. I think the master feeder structure, again, we spoke about a feeder feeding into category 3 AIF and then going into the portfolio. Richie also spoke about how there are models emerging with broker distributors on one end and brokers on one end at the domestic front and distributors outside, and how that is being used to pool and bring capital into these spaces. The co-investment structure also we touched upon, essentially that the have the ability, usually with an FPI somewhere in between, to invest in India and also outside India. Uh, Again,
So I think one strategy we have again seen, and I don't know if this resonates, like there are some private equity houses which invest both in listed spaces as well as private spaces. Not all of them are, modeled in such a way that you cannot exit till the eighth year or 10th year, and not all of them allow complete redemption. So it's a hybrid model which has also evolved in some senses. What happens is that, let's say the fund is of $100 in size, $60 is meant for listed and $40, let's say private equity, or the other way around. So the fund manager can actually earn carry or performance at the end of the year basis how the NAV has moved up on the listed side, and that carries with the manager at the end of the year. Whereas on the private equity side, he will calculate the carry in a traditional end of term or deal by deal, whatever basis. And at the same time, the two cash flows, which is on the private equity side, can sometimes also be linked as how the fund has performed on the listed side. And if there is any carry which has been taken by the manager, there could be a clawback. So it's not as if the investor has participated in two different funds. It's still the same fund, but if the GP has taken any carry on the listed side, it could be clawed back because at the end of the term, the private equity piece did not perform, basis which you took carry. What it also means is that an investor can actually ask for redemption on the public side and yet stay invested on the private equity side. So, these structures are innovative. There are only one or two funds out there which we can think of. Usual names you can all over $1 billion in size. Um, and they allow the manager and the investors to sort of recalibrate a lot of positions, and at the same time allows the manager to earn some carry on an annual basis as opposed to waiting it out till year 8 or 9. So those models are also coming up. Yeah.
One question we are one of the few guys who have this strategy. By the way, we are a small fund, but still we have this.
Great.
But still, so many questions we are also evolving. We are new fund, so that's the reason this question is coming. Are we supposed to have a two NAV kind of thing or one NAV? Because looking from a listed angle side, things are moving on a daily basis, so you can actually calculate it on a quarterly basis. But when you look at private investments, as you said, right, it's a long-term thing. So
Yeah.
if you are reporting your NAV on a quarterly basis to investors, then that might not reflect. I mean, it might reflect true picture, or it might not be
Yeah.
great in favor
So
of you also. So both ways. So
great.
what the strategy should be?
Yeah. So I think you should look at Tata Mutual Fund. They just released the first side pocket, mutual fund side pocket, and that is pretty much designed as hedge fund and these sort of fund models that I spoke about. That as a fund you have two separate NAVs. One which is the liquid NAV, on the basis of which the manager is earning his carry or performance at the end of the year. The other is the illiquid, where I am reporting the NAV, but because these are private companies, I'm not going to report it on a weekly, daily, or monthly basis. 6 monthly or annually, I'll tell you how that side of the portfolio is also performing. As an investor, you cannot redeem out of the private equity side pocket, but you can only liquidate your positions on the listed side, where I am entitled to charge performance fee at the end of the year, or if you're exiting earlier, then I'll charge it earlier. So as a fund, you will have two NAVs, like I said, both separately.
So a follow-up question: would that be acceptable to the next, let's say, fundraise? If existingly, if I'm trying to do a fundraise next time, let's say independently on one side, let's take a private side. So the institutional investor then accept this NAV as a part of your fund, or you would say you have an entire fund. I would look at from that angle.
Right. So, which is where I was saying it's more institutional and larger global funds. What happens is one fund that we know, and again, we won't take the name, it's an evergreen fund. Evergreen fund means that there's a tranche one raise. Let's say there's a 2019 raise. The next raise will happen in 2025 or 26, 2026, and so on and so forth. So, in tranche one, I'll equalize all the investors. You know how equalizations work, right? New money coming in, some premium, time value, and so on and so forth. Then I'll do a tranche two where I'll keep the investors and the portfolio separate. But the same vehicle will evolve as a going concern. It's not a permanent capital vehicle, but at the same time, it's an evergreen fund where each tranche is an independent fund by itself. See, again, we can have an offline discussion, but I'm just saying that all these strategies are, and of course, you're an example yourself. Okay.
I think then we also touched upon the same FPI structures are based out of IFSC. I think for the benefit of the people who are here only for the second session, what we did discuss was that today SEBI has provided some operational guidance around how IFSC structures can be set up and be registered as category 3 alternative fund, investment funds in an open-ended case, and how they can make portfolio investments in India and outside India. They should also be able to accept investment from onshore investors through the LRS, and again be able to deploy that back in India too if required. There is some amount of discussion which is still at least pending in terms of clarity vis-a-vis how they operate, especially with the RBI rules around round tripping was something that somebody had brought up. Around sponsor commitment that may necessarily need to go ultimately from an Indian entity manager to its IFSC manager. IFSCs, I think Richie just touched upon the benefits of the lesser tax, the tax holiday for 5 to 10 years, etc. So an FPI in IFSC is most probably going to look like a category 3 AIF, and then maybe those that regime applies, but it also remains to be seen if you are making FPI type investments, or if you are based on the Khan committee recommendations actually taking up an FPI registration, whether you can then apply the more concessional FPI tax regime to investments in India. So again, like driven by this format of being an open-ended structure, there are a few fun terms that would be material. Largely in terms of LP rights, because this is a different class of investor only probably when compared to a closed-end structure. They have the optionality of redemption in most cases, so they're able to come in and come out. There may be some sort of restrictions on redemption. For example, you may say that for a 2 year period there's a lock in and you will not be able to redeem in that period. Even if you do redeem, you can't redeem the entirety of your capital in the first request. You stage your requests across, say, 3 or 4 half yearly or quarterly periods. So there are various contractual safeguards that can be built in by a GP to prevent complete redemption or immediate flight. But in most cases, these structures do allow for some sort of redemption and ultimately over time complete redemption. In the case of these structures, maybe an MFN or a carve out would be less applicable, because again the logic being that if you're able to redeem and get out, then what is it that you need vis-a-vis other investors? Uh,
Yeah, on MFN, I think the only thing we have seen is around the fee aspect.
yeah,
That as an investor, you are paying the manager typically 1.5. 15 is more prevalent in this space. It can come down to 1% also. But the same time, the MFN clauses typically say that if any investor comes either at the same ticket size or a lesser ticket size than us, then in that case, if you offer a better term to them on the fee, or if you allow them a shorter period to redeem their position, like let's say as an investor I'm stuck with quarterly redemptions, whereas some investor you allow fortnightly redemptions or something of that sort, then that will also be passed on to us. So that is where the MFN clause comes in, that I don't have to be kept aware of who are the different investors coming in, but if you do come out with some better terms, automatically apply that to me as an investor.
yeah. Uh,
What are the major challenge or points that investment manager faces when the LP opts for the redemption in midway, say for example after 2 years or after 3 years? So what are the major challenge from investment manager's point of view means they are facing?
Less money to charge fees on would be the first obvious challenge. The second is that if you're an FPI, obviously you may struggle with the broad-based criteria. The 20 investors less than 49 any one. So how do you ensure that you are still meeting? Because investors are obviously coming out of the platform. If you're an AIF, then of the obvious challenge is that with that investor going out, are you able to keep your corpus above 20 CR or not? Sometimes those issues also come up. Even though an AIF can survive with only one investor, but unlike an FPI, you have to maintain that corpus, right? So those two, three aspects definitely are the most critical. Apart from
How
that,
the liquidity means fund means manage out them?
see, because you would have invested in liquid strategy, something which you can liquidate. So typically, what happens is that if an investor wants a redemption, you tell them that you have to give me 7 day or a 15 day redemption notice before the NAV calculation date, so that I know that I have to generate this much liquidity for you. After the NAV date has sort of come out, I know what is the amount that I have to pay to you. So if I have that much cash balance lying in the funds bank account, I'll pay you that much straight away, or I'll liquidate some of my portfolio to generate that cash to pay out. So that's why even after the NAV date, there's another 7 day or a 2 week period retained by the fund manager. Again, depends on the strategy. If it's a daily liquidity fund like a mutual fund, the rules are very different. If it's a weekly or a monthly, again, it can get pretty tight. So it's driven largely by the liquidity of the portfolio.
It can be
How
like
quickly can you
buyout
generate
by
cash?
some other LP or some new investors.
See, there is no restriction, but as a fund manager, I wouldn't even care, right? All I care about where is the NAV at the end of the year, and I'll charge my performance on that basis. Now, whosoever is the unit holder, if he has sold, if some investor, if let's say I'm charging my performance on 30th of December, and if some investor has sold his unit on 28th of December, the buyer should be aware that in 2 days there will be a reduction in the NAV because the manager is going to charge a performance.
What about the taxes in this scenario? When
If
there is
there's
a
an LP secondary,
yes, secondary.
like an investor has sold his units.
Yes.
So,
Also redemption within the fund or sold to the third party.
different treatments. If you have sold the unit, then you have treated the unit itself as a capital asset. So capital gains is what we're talking about. But if there is a redemption of unit, that means that the fund has actually sold some portfolio, given your redemption, given your distribution accordingly. We want to redeem the units. So there one can take a view that the units of a category 3 AF are not assets themselves. They are simply a mapping structure. See, there's a fundamental difference between mutual fund taxation and AIF taxation. You tax either the investments and exits of the fund and don't tax the investors, or you don't tax the investments of the fund but only tax the investors. The latter is what is followed by equity mutual funds, where equity mutual funds are exempt from all tax, but when you buy and sell units, you are paying tax. You can take the same position or a reverse position, that the AIF is anyways paying taxes whenever it's buying and selling. So I don't have to again pay tax when I'm distributing to investors.
This is debatable.
Hmm?
This is debatable. Under the Act, there is no such provision
or you can get a legal advice and move on.
So, few items. Sorry, just to contrast with our earlier session on LP rights, like also we prefaced, a lot of the rights in a closed-end structure are driven by the nature of the construct that you are tied into that platform for 8 years, 10 years. Whereas here you have a possibility of redemption. So even aspects of, say, co-investments, anyway, it's all liquid. So in most cases, many people can invest, at least from a domestic perspective, or aspects of veto are rather limited. Uh, Again, most likely they are only going to be driven, for example, veto excuse from a very LP, institutional LP perspective, that they should not be investing in some sectors, even if they end up being listed investments, because of sort of institutional overhang that there is. Formats, drawdown, reporting, etc., are, like I think it was touched upon earlier. There is a possibility for these reports to be so much more frequent because there is a daily NAV calculation. So you're able to adhere to maybe a more frequent reporting format. And of course, your fund economics also tie in because you are able to charge on a more frequent basis, maybe a monthly or a quarterly basis, and also provide entry and redemption accordingly on a frequent basis. So all of this ties in to the nature of the open-ended structure. On the governance side, again, just to contrast, you won't really have too many clauses often of cause removal of the manager, etc. Because idea being that if you're unsatisfied, then you can as well just redeem from the product. So those sort of just to contrast with the closed-end fund where you are tied into the manager. This is a slightly different product. Similarly, for early termination is probably not very relevant here when compared to a closed-end, because of the fact that these are vehicles which are expected largely to be sort of continuing vehicles, open-end structures. You don't need to specify a fixed term. So to that extent, they do stick around for longer. So there is no real cause for an early termination. Similarly, like successive funds. On legal and tax considerations, the minimum commitment requirements when we are talking from a SEBI perspective is double in the case of category 3 AIF when compared to the other category 1 and 2. Essentially, the minimum commitment requirement is 5% of the corpus.
Sponsor.
Sorry, of the sponsor is 5% of the corpus, or 10 crores, whichever is lower. One major point of differentiation vis-a-vis category 1 and 2 AIFs is the availment of a pass-through taxation. There is no statutorily encoded pass-through taxation. So, in order to be able to match taxation vis-a-vis your contributors or beneficiaries, you are most probably going to be relying on the trust principles of taxation. I think we just alluded to how you have the choice of either paying it taxes at the trust level and then your beneficiary is then not needing to pay tax, or you have the tax passed on to the beneficiary. But then you are obviously then on the hook as a representative assessee, being the
Correct.
trustee.
So a lot of times we look at these debates like, are we determinate trust, are we discretionary trust, are we revocable, irrevocable, and so on and so forth. So a lot depends on the position you're taking from a tax perspective. By and large, funds tend to pay tax at the fund level itself, because you can have situations where investors came in July, exited in December. So they came and went in within the same fiscal year. So, for what term will they report a tax? How much tax are they paying? Can the trustee be hauled up if the investor has not paid tax? So, it is advisable that let's pay tax at the fund level itself, and let the investors then take a position that, are they going to look at it as a business income accordingly? Do they have any losses? Are they a MAT company or not? And so on and so forth. A lot of variations can come in, but as a fund manager, you perhaps may be better off paying tax at the fund level itself.
But which is where the revocable determinant structure helps. No? It's a double layer guard. One is you say you're determinant, the investor's share is known. Second, it's revocable, so it goes under the clubbing provision and goes as a pass through. So having a revocable determinant to that extent helps, right?
See, it helps if you have. Obviously, principles of trust taxation. Nishith himself has designed the very first trust structure in India for AIG 1996, the first fund. But in any event, the point is that if you have too many investors, you can't literally take the pan of each investor, say that, okay, you tell me what is the position you want to take, we are determinate, we will file the tax returns on your behalf. That you can do only if you have very few investors and there is that relationship. So might as well take a safer position, just pay tax.
Yeah, that is true. So which is I think many funds practically they do take the pan. I mean, that's what I know. They do take the pan and they discharge their taxes as advance taxes on behalf of the underlying the investors in the fund, so that they are not hauled up later.
No, so the point there is that have they paid tax on the pan of the fund or on the pan of the investor?
Investor.
Right, so it is zero tax for the fund.
Yeah, so because it's set up as a revocable return, so that's what practically many of them do.
Sure.
And what about long-term funds? Like part of the income is risen and whole of the income can is there that is.
So see, I think a more common practice in the market today is that can we have two separate demat accounts and earmark one strategy as a core, which is let's say cash equities, put that in a separate demat account, and call the FNO or the high churn as the satellite strategy and put it in a different demat account and defend the position that this is capital asset with a long term horizon and the other perhaps obviously runs the risk of business income, so that you ring fence the tax liability, that your business income does not pollute your 10% income.
So there is a provision in trust taxation, right? That is part of the income is business income and whole of the income. So no capital income once it's not being taxed with every month.
That is true, but that you can still defend by saying that okay, I'm running two books. So which is the risk being run? So by having a clear demarcated demat account, are you at least able to have a defendable case? Otherwise, we wouldn't even have this question, right? Like there is some view issue here.
Yep. So, very briefly on the restrictions as such, category 3 we have touched upon how there are hardly any concessions. On the other hand, there are few restrictions. But one of the abilities, importantly, that a category 3 AIF is allowed, which category 1 and 2 are not, is the ability to leverage. There is, of course, that concomitant reporting requirement, etc., risk management frameworks which need to be set up. But compared to a one or two sort of AIF, category 3 is in a position to actually employ leverage. So there is that flexibility there. Certain other restrictions may sometimes, for example, not even come from Indian laws. An example I can give is like any category 1 or 2 AIF, if a category 3 AIF is marketed in offshore jurisdictions, and this is slightly or often more frequent with retail audiences because there are a lot of NRIs elsewhere who may be already invested in a mutual fund product. The same fund house is running also an alternatives platform, so they may actually go out and market to these NRIs. With the US especially, there is a separate regulator itself for these sort of products, which is just beyond the SEC, which is the Securities and Exchange Commission. There's the Commodities and Futures Trade Commission, which is the CFTC, and they could become relevant for investments into the listed space, into the FNO space especially, and that's where their oversight can apply. There are some de minimis restrictions, so most non-US managers would try to limit themselves in terms of the exposure they take on F&O side to fit certain de minimis criteria that the CFTC has set. Otherwise, you are subject then to a full-fledged CFTC oversight, which is cumbersome or burdensome, especially if only a few of your investors are US person investors. So the restrictions on this front, like I said, could come obviously from category 3 AF regime or even from the offshore regimes, which are slightly more active when it comes to investments in markets. Again, SEBI has a great interest in regulating the markets in India, and considering that between the three categories of AFs, this is the category most likely to have exposure to the markets. There are these larger restrictions around them. Uh, the next issue or aspect we would like to discuss would probably be the Khan Committee report, which, if you want to just give an introduction on what they have done, they have I think 49 plus recommendations, but just some.
Yeah, I think three different directions the report has gone. One, they want to encourage long term patient capital coming to India. Accordingly, they have rolled out all sorts of carpets for pension funds university endowments, upgraded them to Category 2 and Category 1 FPI categories respectively, relaxed the KYC norms a lot for any of these institutional type investors. On the other hand, as far as the regular fund managers are concerned, they will feel more challenges coming out of the report because of two recommendations. One, like we summarized earlier, to meet the broad-based criteria, you need to have 20 investors on a look-through basis and no single investor above 49%. What the recommendation is that they have seen cases where there have been two individuals at 49% each, and a 2% stake was given to some fund, which, by the way, was meeting the broad based criteria on a look through basis. Now, this they say will no longer be allowed. Even that 2% pocket so far that used to be there will now have to become 25% investor of the fund. Now, this obviously is a major change in the regime, and accordingly, they've given 3 years for it to become effective. So, as a fund manager, you can directly approach investors and so on and so forth. We don't completely endorse the position here because if, let's say, the same block of 20 investors who are together holding 2% of the FPI on a look through basis were to directly hold the units of the FPI, so numerically we are still meeting the 20 investor plus, and numerically still we have two investors at 49, and still we have that universe of 20 investors at 2%, and yet it is checking the box for SEBI with this recommendation. So there had to be slightly more concrete sort of revamping of law if that was really the issue that they were trying to address. What they have proposed right now, if this were to be implemented, does not seem that it would address the issue. The second issue that they have again sort of has popped up, and I was sort of summarizing it earlier. SEBI came out with a circular in April saying that NRIs cannot be beneficial owners of FPI. They rolled it back in September, said that okay, NRIs can be the fund managers as long as the entity managing the FPI is itself registered as a non-investing FPI. A single NRI can only be as much as 25% and not up to 49, and NRIs as a class cannot be above 49% in the FPI. For these restrictions to kick in, they allowed a leeway of 2 years from September for existing FPIs and 2 years from the date of incorporation of any new FPI. Because the thought again there was that if a new FPI is being set up, India focused, the first batch of investors that any of these funds would tend to attract would be a more NRI or a OCI type of audience. So, so that was a good thought, and we endorsed the position that was taken in the September SEBI circular. But it is only few months from that circular, and again the Khan committee has recommended that the entire 2 year window that was given out will be cut short to 180 days. And the logic that they have used in that report is that there could be structures which could be set up with a 2 year horizon. They will shut shop on the second anniversary, restart it on the third year again, and again come out with a 2 year life cycle. Now, these are hypothetical situations because they have actually not seen the full 2 years of the circular being affected. If this was truly a concern, that they should have taken that also into reckoning when they came out with the September circular. That it impacts a very specific class of fund managers and investors is a second issue. The first issue we see is that the policy making is still not clear. It still suggests that even the September circular was not well thought through. They came out with a position just to keep the NRI audience happy. Elections were also in the air. So clearly it's one step forward, one step back. So the messaging is not clear unless SEBI conveys that a committee report is a committee report. They don't endorse this piece, and the 2 year will continue as is. But again, it's not sending out the right messages. There are another set of recommendations which are very pro market, which are very helpful, very welcoming. The first I can think of is the whole objective around the protected cell company structure now. There was one instance of a round tripping that was sort of unearthed a decade back, because of which RBI, SEBI, all the regulators had a common, discomfort against PCCs, and they banned PCCs from accessing India as an FPI. Even till date, there is a sort of a representation taken that as an FPI, you are not a PCC protected cell company or a segregated portfolio company, and so on and so forth. 4 years back, what had happened is we were approached by an association from UK which regulates the mutual funds. So after the global financial crisis, GFC, the mutual fund industry was by the regulator asked that you compulsorily have to become a PCC so that the liabilities of one strategy do not sort of pollute the assets of the other strategy. So compulsorily adopt a PCC format. So we represented the association before SEBI, and SEBI issued a circular which said that if the business that you're carrying out in your home jurisdiction requires you to compulsorily become a PCC, and if you give us a representation that you will disclose who your beneficial owners are on a 25% basis, the PMLA regime, so then we will allow you as a special class to operate as a PCC. So it was some opening up of mind around PCC. But now with this report saying that okay, let PCCs also be as eligible to register as an FPI as long as there's disclosure on beneficial ownership, is a very welcome move, because PCCs allows a very clear ring fencing of strategies. I'll give you an example. If we open a PCC in Mauritius or in Cayman, Singapore has also launched an SWAC recently. Hong Kong has started Hong Kong open-end companies, OICs in Hong Kong. All of them follow the PCC format. What it means is that a fund manager only sets up one legal entity, and he will issue new cells for each strategy. One could be long, another could be long short, something else could be very theme based like infra, something else could be with other strategy. But the liabilities of one cell, the cellular assets, will not be held accountable for the liabilities of the other cell or the other strategy. So instead of setting up multiple entities, which adds to the administrative cost, perhaps not making some people in the room that happy, but at the same time, it adds to a lot of operational efficiency. The expenses are pretty much cast in stone, and you have some amount of certainty. Uh, in the past, we have also seen cases where each cell were given independent PAN cards, which is also one proposal that the committee has made. In another instance, where even in a multi-class format, they allow each class, or they now recognize or recommend that allow each class to go for a Cat 2 or a Cat 3 depending on the number of investors and who the investors are. And at the same time, also the department is requested to issue separate unique PAN, so that buying same security in class A, selling it in class B for different strategies should not be commingled, and there should not be a homogenized view taken. So you can have segregated positions from a tax perspective. These two are very good moves. We think if they are adopted, it will really help a lot for foreign participation. The other good recommendation we have seen is the cap for FPI investment. Like today, any listed stock uh, is allowed to take foreign FPI money up to 24%. Rather, reverse. FPIs are allowed to only invest up to 24% of any Indian company as a class. Now, a company through a board resolution followed by a special resolution 75 can move it up to the sectoral cap for foreign investment. So it would mean 49, 74 for different companies in different sectors. What companies had done, they passed resolution to increase from 24 to 26. Somebody increased it to 32, somebody at 50, and so on and so forth. So very haphazard way of increasing the cap up to the sectoral limits. What it does is it makes the free float very difficult to gauge. Now, a lot of global indices like MSCI and so on and so forth, a constant feedback to the regulators and even on their own platforms has been that you have to have a very transparent, bandwidth availability out there. So the recommendation from the committee is that reverse the position. All companies by definition would be allowed to take foreign FPI money up to the sectoral cap, and only if a company passes a board resolution that for XYZ reasons we want to reduce the FPI participation, instead of 49 we want to keep it at 38 or whatever, then they have to reduce it. Instead of the other way around, where you increase the cap to the sectoral limit, it is deemed to be sectoral limit and you can only by resolution reduce it. This obviously would be a very welcome move, because it makes the free float more transparent and hopefully should add to the attractiveness of India's weightage on some of these indices. Uh,
One
sorry.
question in regards with the PCC structure. If the PCC structure has been implemented, won't it open up the renting out of the structure, and what would be its risk of doing so?
So when you say renting out of the structures, to begin with, renting out is never a problem. If you look at European context, there are a lot of UCITS platform which are operated by some of the larger banks who actually allow renting out of the UCIT platform. In fact, the entire package has been so sophisticated They literally tell the fund manager that we'll give you a plug and play environment. You pay us a fee, and for that annual tariff, you tell us how much money you want raised for you. So even the fundraising is part of the package. We'll raise money, we'll give you the environment, you can go retail, you can invest in whatever strategies you want. So having these sort of structures is not uncommon. In fact, there are so many structures which have been raised by overseas arms of Indian corporates itself, who allow Cat 2 or Cat 3 FPIs being set up. I don't know, no need to name
Also,
names.
also that's something even the SEBI took comfort in, that the reason they had this sort of skepticism, like Richie said, was there was this incident, round tripping incident. Apart from that, they felt that the beneficial owners of these structures could not be easily ascertained. But now they have greater comfort because last year they introduced a new beneficial ownership regime where there's a lot of disclosure required, continual KYC, disclosure of intermediate shareholders. And they believe that if they can apply that at a cell by cell level, then they are
So
satisfied.
that part is taken care of this because the PAN card is issued. My thing was more in regards with the tax liability which comes arrive, and then if it's company like parent and the subsidiary kind of a thing which can come in then.
Sorry. So the FIFO issue is acknowledged
Right now.
that first in, first out on the same pan, there is that issue. It's a more wholesome discussion around the treaty being renegotiated. India still taxing capital gains for foreign investors at 10, 15, whatever percentages. So that is somewhat different from the PCC issue.
So it would not be a concern if in
A little bit this way, this is not an added concern. That concern will always be there. In the same cell also, for all you know.
okay, got it.
For FIFO, can't you have two different demat accounts? So the FIFO is for demat account.
It's a defendable position ultimately. How do you defend it? But
It is certainly saying that FIFO is for demat account.
no, I don't think of.
So, anyways,
For foreign investors, you
FPI,
anyways can't have different demat accounts.
FPI is having a CP code, cannot have multiple demat accounts.
Okay.
It's only under an domestic AIF structure they can have.
Okay.
So on PCC, we have one more thing. So the regulation now says that any opaque structure can be registered as an FPI. If you see the FPI regulations 2019.
This is still a
No,
recommendation.
it doesn't say that.
If you check the regulation, it says that an opaque structure, including a PCC, can be given an FPI license provided it fulfills four conditions. One is
Okay, so I understand what you're saying. Now I'll tell you the issue with it. This is an issue coming because that circular I was talking about for the UK mutual fund industry. Okay, the circular that was actually issued to relax all this actually gave 5 conditions, 3 or 4 of whatever you mentioned, plus one added condition which is not there in the FAQs. That condition is that you were required to be set up as a PCC because of whatever you're doing in your home country.
that says so.
That requires you to be a PCC. So,
That's not
so you
fair.
cannot on your own choice adopt a
Oh.
PCC and then register that as an FPI. It's only if your business is such that you can only operate as a PCC, only then.
So, assuming we have been asked by the home country's regulator that you need to be as PCC, but the regulation has of the four conditions that has been mentioned there. One says you need to be a broad-based fund, or a sub fund also has to be broad-based. So, how in PCC you will say you are broad-based? Will you count the investors at the core, or at each cell has to be broad-based?
See, it depends on who's taking the FPI license, right? So if the FPI is taken at the PCC level or each cell level, each cell can have its own PCC, can have its own FPI license. So if one cell is an FPI,
Yeah.
then obviously the broad-based criteria has to be met by that cell alone.
So what if I say I take a Cat 3 license? Then also
For the cell or the entire FPI, the entire PCC.
for the PCC, for the entire PCC.
So that position is no different from multi-class structure today also. Today, as any standalone collective investment vehicle or a IC, you take an FPI license. Now, whether you issue class A, B, C, D, doesn't matter. If there's one FPI license, then you can count all the investors in that vehicle.
So this regulation is you have to if so as a PCC you can apply for a Cat 2 or a Cat 3
At each cell level.
at each cell level.
That is the recommendation from the committee. Till that recommendation fructifies, you cannot. What you can do today is only go for a multi-class vehicle, and each class can go for its own FPI license. And there are many such structures already out there. where class A is Cat 2, class B is Cat 3, and each has its own separate demat account also, and a separate PAN in one instance, which we don't agree that should be possible, but yeah.
With this recommendation of SEBI, if each PCC is applying for the FPI license, looking at to the UBO consideration that they will disclose the ultimate beneficial owner, will that impact in the clubbing of investment because each cell will have a common beneficial owner? Will
Need
that
not. So each cell can have its own different investors. And the clubbing rules, okay, by the way, is also very contentious.
Yeah,
What they have said now is that you look at 50% common ownership, you look at common control, and then they are also trying to club FP and FDI. That is a separate discussion by itself, and I don't know if there's some appetite in this room. Like if as an FPI you go beyond 9.99%, you have a 5-day window to sort of classify yourself as an FDI investment. What that means is that you can no longer acquire more shares on the floor. So let's say I have two arms in the structure. One is an FDI investor, another is an FPI investor. Then once I have done an FDI investment in a company, let's say pre-IPO, and the company got listed, then my FPI arm cannot invest under the FPI route if the aggregate holding is going beyond 9.99. So basically, the idea is to not allow strategic investors to tap on public platforms which are meant for retail participation. The moment you go beyond 9.99, we would not want you to acquire or sell on the floor as an FPI, because now you have become strategic, and your buying and selling can hurt the retail audience in India. So that perhaps was the motivation, and the
So,
committee has just put out some more rules around
so
it.
clubbing for say today clubbing already applies vis-a-vis the 10% limit for FPIs in an investor group. An investor group is reckoned only vis-a-vis the other FPIs. What this committee report suggests is possibly that you may also need to look at, like Richie said, beyond the FPI investor group, whether there are others in the investor group who are investing through other routes like FDI, and whether they should be clubbed for the 10% limit.
Any questions on this piece or any views you have, because this is obviously evolving thought. In fact, there were transactions where bankers allowed FPI investments even though another affiliate had already done FDI, and so obviously we see some gap between the law currently today and how it is implemented, and hopefully be with the committee recommendations, if they are followed, then there'll be some clarity, but there is some gap today. And
The only thing that comes to my mind is the clarity which SEBI has recently given to a category of investors as a pre-qualifier for making investments in entities, startup entities. So, in a similar fashion, if all across all the investors are kind of pre-qualified, then that may kind of save a lot of time for the rest of the entities to kind of avail funds from it.
yeah, but will the effort is to find those investors, right? Finding investors is always a
Yeah, true. There was a challenge. I think we have somebody from Bombay.
So
yeah.
Yeah, that's right. Yeah. So yeah, we have a thought there.
No, but see, okay, the FPA program is meant more for investments into liquid strategies like cash equities, derivatives. We'll be happy to take the discussion on the VC side separately.
These are two separate
Yeah,
conversations. So, two things. So, one is what the recommendation says is harmonization of FPI and AI, precisely in a context where you've got an AI having investments more than 50% will qualify as an offshore fund.